7:32, time to get some of those legal questions you've been sending in answered. And we're going to go to senior legal analyst Chris Tritico. Good morning, Chris.
Good morning, Jose.
Okay, got some good ones for you here. The first one comes from Esther, who writes, on May 29, 2021, I purchased an extended service contract on a new 2021 Nissan Rogue. I decided to cancel it May 31st. I signed the paper to cancel it May 31st, but it was not canceled. I have not heard back from the sales manager or the finance manager. I have sent numerous emails, called, and sent a certified letter with no response. On June 21st, finally spoke with the finance department and was told I would receive an email with the new finance information the following week. I did not receive anything. What can I do?
Well, you've done everything you can do on your own, in my view, and now you're going to have to hire the lawyer of your choice, I think, to help you with this. There's nothing else you can do on your own to force them to do the right thing here. And I'm assuming your contract said you had a rescission period and that you met that rescission period. If you're outside the rescission period when you sent the email rescinding the contract, then they have a right to force you to keep it. Contact the lawyer of your choice. Take all your paperwork, all your emails, and your certified letter. Take everything there and let them take a look at it and see if you have a cause of action against them for breach of contract. If you do, they'll take it for you and they'll take the ball from there and see if they can't get this solved for you. That's really all you have left. Good luck.
Our next question comes from John, who writes, what can be done to have CenterPoint fix damage they caused in my yard from a leaf repair? I have been given a claim number and told several times that someone would be contacting me to schedule a repair, but no one has. There are ruts from the tractor, a hole, a damaged French drain, bare spots where they worked. Is there anything I can do to hold them liable for the damage to my yard they caused in order to get to their easement? Any help would be appreciated.
So there's several things I think you can do. And the first thing that I've found particularly helpful is a free thing, and that's social media. Take pictures of what they did and show that it was them who did it and post it on social media. Tag them in it and post it on their social media as well, and point out how long you've been trying to get them to do the right thing and that they know about it and they've given you a service number and they won't come out and fix it. And once you do that, it's amazing how quickly you're going to hear from them, and see if that helps. If that doesn't, then the next thing you need to do, I would start calling and not talk to the first person you hear, but tell them to send you up the chain of command and keep going up the chain of command. Failing that, then I'm afraid you're going to have to contact the lawyer of your choice. But try those two free things first and see if that helps. But social media is such a powerful tool these days. See if that helps you. Good luck.
Our next question comes from Eva, who writes, we sold our home that was flooded by Harvey. Next door to it sat our toy hauler on our .40 acre lot. Now, after we sold the house, we bought a truck to tow it. We went over to get it, but discovered it was taken by the people who bought our home. Our former neighbors saw a locksmith unlock the lock we had on our toy hauler. They were told by the new neighbors that the trailer was included with the home. Now, we called the police and give the police the person's information. He told the police that he had an agreement with us that the trailer was included in the deal. The police will not touch the case and says it's a civil suit. We learned that they are trying to do a little salvage title on the trailer. Now, the toy hauler is still in our name, and the people who took the toy trailer will not tell the police where it is being stored. I have since contacted a lawyer. However, they want to see a survey on the property which we owned. Does it matter whose property it was on? What else can we do?
So it absolutely matters whose property it was on. If the toy hauler was on the property you sold, then they have a reasonable claim that it went with the property. And so that's why the lawyer you hired wants to see a survey and wants you to show them that the toy hauler was on your .4 acre piece of property and not the property that you sold. You have a claim here. Work with the lawyer that you hired and get with them quickly so that they can go in and file a lawsuit with a temporary restraining order and a temporary injunction restraining them from selling the toy hauler. If you don't do that, you're going to lose it. So get with that lawyer as soon as you can. Get everything that that lawyer's asked you for so that they can get suit on file as quickly as possible. That's your best road to saving that toy hauler. In a suit like that, you're entitled to your attorney's fees back as a judgment against them. So get with that lawyer. They're doing the right thing for you. Good luck.
Thank you, Chris. Now, we want to let our viewers know that if they want to send you their legal questions, they should just go to our website and fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for specific information or advice, contact an attorney of your choice.